Right. Good morning. The date today is the 31st of January 2023. The time is 08:35. 25 minutes to 9 in the morning. Okay, today we're doing learning unit 4 of the Administration of Law ADL 2601. Right, let's begin. Learning Unit 4, the sources of administrative law. Working through this learning unit should enable you to explain what is meant when we refer to the sources of law in general. Explain the importance of the identification of the sources of law in general and administrative law in particular. Classify and examine the sources of administrative law. Apply these sources to factual, concrete situations. The outline of this learning unit is as follows. 4.1. What are the sources of law? 4.2. The sources of administrative law. 4.2.1. Binding or authoritative sources. 4.2.2. Persuasive sources. 4.3. Where to find administrative law sources. 4.4. How to find the sources of administrative law in a particular situation. 4.5. Conclusion. What are the sources of law? The sources of law are the places where we can find the legal rules, norms, principles, and values that govern a particular branch of the law. In the context of administrative law, as part of public law, we could say that the sources of law refer to the sources of public or authoritative power. It is in this sense as a reference to the sources of power that Paja refers in section 1 to an empowering provision. The state authority to act in terms of administrative law must therefore be authorized in a specific source of law. Where are the legal rules, but also the principle, norms, and values governing administrative law to be found? In other words, where do we find legal rules that confer the power on any organ of state or functionary or institution to take administrative action, prescribed the procedures to conduct by any one in authority and control their conduct? It has been said that administrative power is not self-generating, but is conferred by law. Baxter, 1984, page 384. One of the groundbreaking writers on administrative law. Oh my God. I forgot to scroll here. Okay, let's proceed, guys. We ended here at Baxter. One of the groundbreaking writers on administrative law wrote in the early 1980s, long before the new constitution dispensation came about, that power means lawful authorized power, and that public authorities possesses only so much power as is lawful authorized, and every administrative act must be justified by a reference to some lawful authority for that act. The power to act must therefore be authorized mostly in terms of legislation. When you think back on your introduction to law module, you will recall that on all the sources of law have the same authority. Some laws are more authoritative than others. Hence, the distinction between laws that have binding authority and those which merely have persuasive authority. For example, our Constitution is the most authoritative and thus binding source of law. The laws of foreign countries such as India, United States of America, Germany, or Canada have only persuasive authority or influence. The laws of these countries can be examined when more guidance is needed to decide cases dealing with issues that our courts have not faced with before. Activity 4.1. We just explained what the sources of law in general are. We also explained what sources of law refer to in the context of administrative law. Now that we have a general idea of what sources of law refer to, try to answer the following question. Where would you look for a legal rules governing administrative law? Make a list of sources you can think of and compare your list to that contained in the discussion which follows below. Keep in mind that sources of law are more authoritative than others. The sources of administrative law: binding or authoritative sources. 1. The Constitution of the Republic of South Africa 1996. 2. Legislation. 3. Case law and judicial precedent. 4. Common law. 5. Administrative practice, custom or usage. 6. Ubuntu. 7. International law. Persuasive sources: writing in books and journals expressing academic opinions. Policy documents such as green and white papers. Reports by state institutions supporting constitutional democracy such as reports of the Human Rights Commission. 4. Foreign law. Please note, it should be noted from the outset that Section 33 of the Constitution and the provision in the JAPA are intended to regulate administrative law in South Africa. The most important rules and principles that apply to this area of law are therefore covered in these provisions. Whenever you are required to answer questions for assessment purposes, keep in mind that the most authoritative sources for this module are Section 33 of the Constitution and the enabling provision in JAP. In addition to these sources, case law, the common law, and so forth are also sources of administrative law, which may be very well covered certain aspects not covered by Section 33 and PAJA. The sources of law that are applicable to administrative law are covered in this guide. There is no need to consult any additional sources. Binding or authoritative sources. The Constitution. The 1996 Constitution, with its entrenched Bill of Rights, is the supreme law of South Africa. As the supreme law of the country, it is the ultimate source of law and ranks above all the other laws of the country. In relation to the administrative law, as with other branches of public law, the Constitution is also the principal source of power. No other law, whether legislation, case law, common law, and customary or indigenous law or conduct, may be in conflict with the Constitution. Section 2 of the Constitution reads, Supremacy of the Constitution. This Constitution is the supreme law of the Republic. Any law or conduct inconsistent with it is invalid, and the obligations imposed by it must be fulfilled. The Supreme Constitution is that not only by far the most important statutory source of administrative law, but the most authoritative source as well. Moreover, the Supreme Constitution also serves as a check on public power, since the exercise of such power must be in line with the Constitution. The implications of the supremacy for administrative law are twofold. First, as the supreme law, the Constitution sets the standard for the exercise of power and thus the actions of every organ of the state or functionary or institution in South Africa. Secondly, the Constitution promotes and guarantees a culture of human rights. In the administrative law context, the Constitution insists on justice for the individual by commanding that all the requisites for valid administrative action, lawfulness, reasonableness, and procedural fair must be met. The Constitution therefore guarantees the right to just administrative action to any individual in terms of Section 33. In Pharmaceutical Manufacturers Association of South Africa, Henri Expert, president of RSA 2000, 2SA 274, CC, Jackelson P., the then president of the Constitutional Court, observed the following about the interim constitution, paragraph 45. The interim constitution shifted the constitutionalism and with it all aspects of public law from the realm of common law to the prescripts of a written constitution which is the supreme law. Note that this observation holds true for the 1996 Constitution, the final constitution as well. Note, the concept of administrative action is discussed in the next learning unit, and the content of the right to just administrative action is discussed fully in learning unit 7 to 10. Activity 4.2. Reread scenario 1 to 4 learning unit. For which of these scenarios would you use the Constitution as source? Explain why would you turn to the Constitution? We must use the Constitution in each of the 4 scenarios. We have said the Constitution sets the standards for the exercise of administration power by organs of the state and functionaries as well as institutions. Regarding the scenarios, we find that power was exercised by organs of state, functionaries, and institutions. This conduct must therefore be in line with the constitutional provision. We have learned that Constitution supports a culture of human rights. A culture of human rights starts with the way such authoritative power is exercised. 2. Legislation. Legislation is primary source of administrative power. One of the reasons given for this is that administrative law is a relatively modern branch of public law. A more convincing explanation is that since legislation is readily accessible and knowable, Du Plessis 2002, page 22, it logically follows that administrative power has almost always legislation as source. All legislation must comply with the provisions of the Constitution. However, note further that although the Constitution sets the standard for conduct, it obviously cannot deal with every aspect of interaction between authorities and individuals. Parliament, the legislature, is often instructed to adopt legislation to give effect to a constitutional provision. Legislation adds flesh to the bones of principles, norms, and the values expressed in the Constitution. For example, the Constitution requires that Parliament comply with its constitutional duty to pass legislation dealing with just administrative action to make it effective. Section 33, subsection 3 of the Constitution, we distinguish between original and delegated legislation. One second. The distinction and its validity in the light of the Supreme Constitution are dealt with in the interpretation of status modo. We only provide a brief explanation of the original and delegated, so-called subordinated legislation, and examples of each. Enabling original legislation. Enabling original legislation is passed in Parliament, national sphere of government. 2 examples of acts of Parliament that complement the provisions of the Constitution and are crucial to the administrative law as well are the Promotion of Administration Justice, Act 3 of 2000, the Promotion of Access to Information, Act 2 of 2000 per year. See Section 32, subsection 2 of the Constitution. Note, very important, the provision of PAJA will be discussed in Learning Unit 5 when we examine the concept of administrative action, and the subsequent learning units when we deal with just administrative action and remedies. PAJA, read with Section 33 of the Constitution, is a principal act that regulates administrative law. Most aspects of this area of law are therefore dealt with in the Act. If certain administrative law principle is covered by PAJA, then that would be your main authority. Read with Section 33 of the Constitution. Original legislation is also passed by 9 provincial legislators in their provincial sphere of government in terms of Section 104. Read with Schedules 4 and 5 of the Constitution. For example, the Constitution provides that school education is a matter that is primarily governed by the provincial sphere of government. Examples of provincial legislation are various school education acts passed by legislature of the 9 provinces, such as the Gauteng Schools Education Act 6 of 1995. In the local sphere of government, original legislation is also passed by elected local government, the municipal councils. The local government has the power to enact bylaws that do not conflict with the Constitution or any parliamentary statute or any applicable provincial statute in terms of Section 156, subsection 2. In Virtual Life Assurance Ltd versus Great Johannesburg Transitional Metropolitan Council 1998, 12 BCL R11458 CC 1999, 1 SA 374 CC, Constitutional Court said paragraph 38, the constitutional status of a local government is materially different to what it was when Parliament was supreme. Local governments now have a place in the constitutional order, have to be established by the competent authority, and are entitled to certain powers, including the power to make bylaws and impose rates. The Constitutional Court concluded that these bylaws constitute original legislation. The reason put forward by the court was that the municipal council was an elected deliberative body which, like the national and the provincial legislatures, derived original legislative power direct from the Constitution, paragraph 26. Delegated legislation. Delegated legislation is also called subordinate legislation. The distinctive characteristics of the delegated legislation is that it must be enacted in terms of the original legislation. In other words, such legislation must be authorized by the enable or empowering original legislation. Another feature of delegated legislation is that such delegated legislation must not conflict with the provisions of the Enabling Act. Du Plessis, 1998, 2C, page 19, explains that the objective of delegated legislation is to regulate matters provided by the original legislation in a broad outline only. He explained further a bit. Organs of the executive are often a better position to deal with certain matters once the parameters with which it is competent for them to do so have been set by empowering original legislation. Regulation through delegation legislation is often resorted to when the matters to be regulated are of a sophisticated or technical nature. In the national sphere of government, delegated legislation is passed by functionaries who are empowered to make these rules. Examples are proclamation of the president in his executive capacity, such as proclamation issued in terms of empowering statute to declare the date of commencement of a particular statute, regulations made by ministers, the members of cabinet of the national executive in terms of enabling a statute. For example, we've got an example here, Government Gazette. There is a number in Pretoria, it was in 2000, proclamation, President of South Africa, R22, 2000, declaration, 1st of April 2000, as the commencement date of the Refugee Act. So it's about the act that was done by President Thabo Mbeki. Okay, we've got example 1, which is this one. And we also have another example of Home Affairs, which is this one. It was on the 15th of September 2000, Refugee Act 1998, Act 130 of 1998. The Minister of Home Affairs has, in terms of Section 38 of the Refugee Act, made regulations in the schedule. Here is our second example. So we're going to now move to page 42. All right, let's get moving. Okay, before we move to page 42, we just need to finish there. Delegation legislation may be found in the provisional sphere of government as well. For instance, regulations issued in terms of School Education Act 6 of 1995, Gauteng, by that province's member of the Executive Council for Education, the MEC, and so on. Regulations are also issued in sphere of local government, for example, regulation in terms of the relevant bylaws are issued to regulate traffic in a particular municipal area, and so on. So we've got activity 4.3. Okay, return to scenario 1 to 4, learning unit 1. Do you think it is necessary to consult legislation to know what the law says about different situations the characters find themselves in? Explain your answer. Would you look at the original legislation only, or would you extend your search to include subordinate legislation. Okay. What we have said about legislation is relevant to all four scenarios. The Constitution has created the broad constitutional framework. It is then left for legislation to address and control particular identified issues. In all our scenarios, the expulsion from a school, scenario 1, the withdrawal of the temporary permit of a refugee to stay in the country, scenario 2, the suspension of an educator, scenario 3, and the refusal to give a tender, scenario 4. We must search for legislation dealing with such matters. The legislation constitutes the empowering provision allowing to administrators to act. We then need to extend our search and inquire whether any delegation legislation was passed dealing with these matters in more detail. 3. Case law, judicial precedent. It is the task of the court to determine the meaning of the particular legal rule. That is, to interpret the legal rule in line with the prescription and values of the Supreme Constitution and relevant statute law, and to apply such rules to concrete particular factual situation. Exactly how this is done, for example, the application of the rules and guidelines of interpretation of legislation as prescribed by the Constitution, is the area of focus of the interpretation of status module. Note specifically that the interpretation of status, such as PAJA, by the court is an essential part of administrative law. Some core principles, as stated in PAJA, are identified and clarified by courts. We will specifically mention these cases where applicable. An even more important role of the court is to control the exercise of public power and the performance of the public functions by organs of state, functionaries, and institutions. In Pharmaceutical Manufacturers Association of South Africa and the expert president of the Republic of South Africa, refer above, Shackleton P. held that the change brought about the new constitutional dispensation meant that the courts no longer have to claim space and push boundaries to find means of controlling public power. That control is vested in them under the Constitution, which defines the role of the courts, their powers to relation to the arms of government and constraints subject to which public power has to be exercised, paragraph 45. The structure of South African judicial system and the functions of the judicial authority as provided for in the Constitution and relevant statute law are dealt with in constitutional law module. It is important to remember that because past judgments are binding on other courts in subsequent cases, the judicial precedent decisis rule, it is obvious that case law forms a material source of administrative law. Activity 4.4. Okay, let's move. Read the course decision included in the study guide as Annexure B. The Earth Live Africa case. Start by reading rapidly through the text to get general idea that the issue involved watching out the rules of administrative law may be involved. Then reread the decision and make notes under the following headings. 1. The facts of the decision. 2. Identification of administrative law issues. Remember to indicate in your notes where the decision you found your answer. This is important. Whether you are writing an essay or article for academic purposes or developing an argument to present in court. If you feel uncertain about how to go about reading the court case, you will find useful guidance in the text English for Law Students by Van der Vaart and Nienaber. Another useful work is Beginner's Guide for Law Students by Klein and Viljoen. Since this decision will feature in this guide again, we will concentrate only on the facts and the question whether administrative law issues are involved. We will be focusing on the use of case law to determine how the courts have interpreted the applicable legal rule of administrative law and how the courts have applied them to a particular situation. 1. The facts of decision. The facts of any decision are usually set out right at the beginning of the report. In the Earth Live Africa, the decision under discussion, the facts are quite straightforward. The story is told in paragraph 10 to 20 under the heading Factual Background. You should not have any difficulty summing up the facts in a few lines. Unfortunately, the facts of some cases are extremely complicated and very technical. This makes reading of such decisions more difficult. Identification of administrative law issues. The decision is user-friendly in that the issues to be dealt with by court were spelled out. An application for review of administrative action, a decision on certain grounds and the merits or demerits of the requirement that internal remedies should be exhausted first. 4. Common law. You are encountered the meaning of common law in the Introduction to Law module, but to refresh your memory, the common law is the unwritten law of South Africa in the sense that it is not written up in legislation. Common law is not an important source of South African administrative law. We have seen that the main source of administrative law are the Constitution, Paja, and other legislation. Nevertheless, English law in particular and Roman Dutch law to a lesser extent have both contributed to the development of administrative law. 2 examples of common law rules in English law of origin. 1. The principle of ultra vires, and 2. The development of the rules of natural justice. The meaning of principle ultra vires will be discussed more fully in Learning Unit 7 and the rules of natural justice in Learning Unit 9. Note that many common law rules are now included in legislation. We will see, for example, that the rules of natural justice we have referred to are now included in PAJA, the Act to be discussed in detail in a later learning unit. 5. Administrative practice, custom, or usage. Just a few seconds just to catch up with myself. All right, let's get moving. Administrative practice, custom, or usage. Custom made up of unwritten rules or fixed practices which communities have carried down from generation to generation and which they regard as binding. African customary law also forms part of the broad definition of custom. This fact is acknowledged by PAJA through the inclusion of customary law. In the definition of empowering provision in Section 1, the custom must meet the certain requirement. It must be reasonable. It must have existed over a long period. It must be generally recognized, accepted, and observed by the community. The content of the custom must be certain and clear. Administrative law, the question must be asked whether administrative practice or custom can acquire the force of law. In other words, that administrative practice such as internal directives, circulars, policy guides, and so on, that is instruction to make the management or running of department easier, acquire the force of law and be regarded as a source of power over time. This is a difficult question to answer. It would appear, though, if the definition of the empowering provision in Section 1 of PAJA includes such circulars, directives, which its reference to, an instrument or other document in terms of which an administrative action was purportedly taken. For the purpose of this module, it is enough to remember that custom as a source of administrative law is exception rather than the rule. Moreover, like legislation, common law, and custom, including African customary law, are subject to the Constitution. In other words, the courts will not recognize a custom that conflicts with either the Constitution or legislation. Right. We're going to end here for now, and then we proceed from page 44, which is Ubuntu. Okay, we proceed. 6. Ubuntu. At the conference of the Commonwealth Legal Education Association, CLEA, Professor Emeritus Josh Davenish, Senior Research Associate, University of KwaZulu-Natal, presented a paper entitled Preventing Corruption and the Misuse of Funds. How can law teachers assist in the fighting the scourge of corruption in Commonwealth countries and other common law countries? In this paper, He also briefly explained the meaning of Ubuntu. The paper is available as per this website for this event. Okay. Durban 2013 conference paper is written Ubuntu. Ubuntu actually means humanness. See State versus Makwanyana. And there is a case, and it was acutely reflected in the preservation and stability of the whole community. Its operation within the codes of tradition and law was evident in time of war, when women and children were never killed. See Monster Frontier 197, Epic Scientific Creation and Strategy of Xhosa People. Ubuntu therefore underline the entire basis of their strict code of social laws. Excuse me. The African scholar Sogo explained that the primary object of Xhosa law is to preserve the tribal equilibrium. The law therefore guides the individual towards keeping the tribe from disintegration. See Amakosi customs. Constitutional Court Judge Yvonne Mokgoro explains that Ubuntu serves as the basis of morality, of cooperation, compassion, community spirit, and consent for the interest of the collective. For others, and respect of the dignity of a personhood, all the time emphasizing the virtues of the dignity of social relationship and practices. State versus Makwanyana, paragraph 308. In the social and political culture of the Xhosa people, the chief played a pivotal role. In principle, everything and everyone belonged to the chief. See Mostert Frontier 9, page 199. On the face of he possesses unlimited power and was able to impose any tyranny he wishes. See Monte Frontier, page 199. However, in reality, the situation was vastly different. The relationship, as explains Mostert, because between the Xhosa chief and his subjects was finely balanced. So, for instance, the loyalty a Xhosa chief commanded depended upon the way in which he used his privilege and prerogatives. This meant, in practice, there was no unconditional acceptance of the tyrant. See Motrain Front 199. In practice, the chief was accountable and subjected to checks and balances upon his power. They arose from the fact that the lack of any central apparatus through which absolute control could be exercised. An important safeguard against the abuse of power by a chief was affected by the influence of his group of councillors, known as the Amapakati or middle ones. In effect, they constituted his parliament and Supreme Court. See Fontaine, page 199. He governed he governed their advice and was indeed not expected to go against it. Although the chief was the head of the council, whether this applied to a chiefdom or a nation, he dare not veto a decision of his court except at the peril of her reputation and authority. See Mr. Frontier, page 199. The Xhosa people laws and courts of law, furthermore, there was a powerful tradition for democratic debate and a gift of logic that impressed outsiders. Nevertheless, the Xhosa world was most certain not perfect, like other societies, including Europe ones, was susceptible to greed, malice, envy, conspiracy, and darkness as any. African people had their own religion, their own ethical views, and their political system and philosophy before the advent of European colonizers. There was a distinctive collective consciousness that manifested itself in certain behavior patterns and spiritual self fulfillment. This, as indicated above, is described as Ubuntu and is an African view of life and worldview. It can be described as African humanism involving almsgiving, sympathy, care, and sensitivity for the needs of others, respect, patience, and kindness. Ubuntu takes serious the view that the man is essentially a social being. African Ubuntu thinkers formulate their own views in terms of a person is a person through other persons. Ubuntu style management involves a departure from hierarchy, structured management, as well as the introduction of corporate and supportive form of management in which the collective solidarity of various groups employed is respected and enhanced. Ubuntu is a social survival technique that developed from socio-economic and demographic circumstances in which African people had to cooperate to survive. In certain respects, Ubuntu corresponds to social democracy, to which it is certain affinity in terms of industrious individual efforts, which are lauded and rewarded as long as they are altruistic. Ubuntu requires the right balance between individualism and collectivism, and it is made possible by taking people's need for dignity, self-respect, and regard for others seriously. It requires consensus management in that it emphasizes is not in differences but on accommodating differences. It should be noted that the interim constitution stated the need for Ubuntu, but unfortunately, this authentic African concept does not feature in the current constitution. We have sacrificed the textual foundation encouragement for the furtherance of a truly African jurisprudence. Nevertheless, the idea has a universal significance lives on as most certainly not be extinguished. Number 7, international law. In terms of the Constitution, international law is an equal important source of law. As far as administrative law is concerned, however, it plays a lesser role. Nevertheless, should it become necessary to look into international law, we have to examine what Section 39, subsection B, subsection 1, subsection B, 231 to 233 of the Constitution prescribe in this regard. You will learn about the topic of international law and the international law model. International law regulates the relationship between the states and or international organization. It comprises mainly of treaty law and international usage. Persuasive sources. There are other sources of South African law that are not authoritative sources. That is, they do not have the same binding force as constitutional legislation or case law. However, they do have persuasive influence in our law. In other words, they influence legislation and judicial decision making and are therefore important. Examples are discussed below. Writings in books and journals express academic opinions. The court often refers to academic opinions expressed in law journals and books. Policy documents such as green and white papers. Currently, government policy on various topics is expressed in so-called white papers and green papers. In this document, government policies on a vast range of matters are set out. A green paper is a consultative document. In a participatory democracy, the people of South Africa, should participate in our governance. Or, to put it differently, we should have a say in how we are ruled by authorities in power. Through green papers, the people are invited to comment on various matters. A green paper is a consultative document. In a participatory democracy, the people of South Africa should participate in our governance. Or, to put it differently, we should have a say on how we are ruled by the authorities through the green paper. The people are invited to comment on various matters to be regulated by government. White paper is a final document in the process, which includes the expression of government's commitment to something. This action that will take and will be implemented of policy. The white paper is a blueprint or outline of government policy on various matters. An example is the white paper on the renewable energy policy of the Republic of South Africa, N513/2004, the Government Gazette, number 26169 of 14 May 2004. Reports by state institutions supporting constitutional democracy. These institutions, such as the Public Protector and the Auditor General, also called Chapter 9 institutions, report on administrative conduct, and make recommendations to the legislature on how to cure any maladministration or abuse in the exercise of authoritative power. You will learn more about these institutions in Learning Unit 11. Foreign Law. Section 39, subsection 1c of the Constitution states that the courts may consider foreign law. They may choose whether to turn to the law of other countries to assist them in cases where insufficient guidance from South African law is available. Being foreign law, we mean the law as found in the law, case law in particular, of countries such as USA, Germany, Canada, India, and Namibia. Where to find administrative sources? If you're looking for legislation, you may consult any of the following government gazette published and printed government printer, the loose leaf annual collection of status published in LexisNexis, Pretoria, internet. There's a website there as well. If you're looking for case law, there are many number of places where you can find case law relating to administrative law and administrative method, including the most comprehensive collection or compilation of South African case law is to be found in the South African law reports, which are published monthly by JUTA. The SA law reports contain cases of every kind, not only those of constitutional nature. Constitutional cases, including administrative law, are also published separately in the Butterworth Constitutional Law Reports. If you have access to internet, you may also access the latest decision of the Constitutional Court and Supreme Court of Appeal on the webpage of Law of the University of Witwatersrand. They give us the websites. If you're looking for articles dealing with administrative law topics, these are published on several journals. Two of these South African journals specialize in public law, constitution, administrative, and human rights issues. Southern African Public Law, which is published by Verloren van Temmet Centers for Public Law Studies, UNISA. South African Journal of Human Rights, which is published by JUTA. If you are looking for policy documents and reports for government institutions, and you have access to internet, you have accessed them on the government website. There's two of them. And then we move to 4.4, how to find the sources of administrative law in particular situation. Let's go. Scenario 10. Miss Lucy Green is convicted prisoner serving a sentence of 6 years imprisonment. She was convicted of fraud in the form of tax evasion exceeding 2 million. After 13 months in prison, she is diagnosed with inoperable illness and is not expected to survive for more than and further 12 months. She applies to be placed on parole on medical grounds. The application to be placed on parole is rejected. The grounds for refusal are, amongst others, that all the appearances Lucy does not look ill and is still good health. Hers is a high-profile case. There are penal consequences attached to her parole. in that she has served less than one third of her prison term, and there is the possibility that she will commit a crime again. Moreover, one of the policy guidelines of the department to determine whether parole is in actual fact expedite on grounds of physical condition is that an injudicious placement or release on parole may foil the panel objective of the sentencing authority. Activity 4.5. Carefully read scenario 10 again. Which sources would you use to argue Lucy's case against the Department of Correctional Services? Since the Department of Correctional Services is involved in government department with public power, and since Lucy finds herself in a vulnerable position in terms of the department, she is terminally ill and her application for parole has been refused. You may safely say that administrative law is involved. You would obviously first turn your attention to the Constitution. The Constitution set out standards that will have to be used to protect the individual against the abuse of power by the organs of state, functionaries, and institutions of authority. One of the fundamental rules of the Constitution is that all such actions must be consistent with the previous of the Constitution, Section 2. Also, the Constitution contains in the Bill of Rights the right of everyone to administrative action that is lawful, reasonable, and procedural fair. Section 33. Read together with relevant provisions of PAJA. Lucy may claim the protection of the Bill of Rights against the power of the state. See more about the aspect later in the guide. We have seen that the Constitution creates only the broad constitutional framework from government action and interaction with the people and the community. To argue Lucy's case, you have to investigate further whether there are any specific legislation provisions dealing with someone in the position of Lucy. You need to first turn to empowering original legislation. You will find that the Correctional Services Act deals with, amongst other things, matters of parole. Although the minister or another administrator to whom power has been delegated, we will learn more about delegation later in this guide, is empowered to refuse parole. The Act provides when and under what circumstances such a refusal may occur, the grounds of refusal of parole. It also provides the procedure to be followed in the event of refusal and whether and when a person may appeal to a high authority within the department against the refusal. You also have to examine the regulation. With the minister is empowered to issue in terms of the Act delegated legislation. Such regulation may regulate certain specific issues relating to the granting or refusal of in greater detail. The regulations may therefore contain more detailed information on how to deal with matters of parole. For example, matters such as the form of application for parole, the composition of the body or bodies deciding on such matters, and their function, and so on. You may, of course, also consult policy guidelines. Another source of law you need to consult is case law, judicial decision. You also need to inquire whether the courts have already decided on situations similar to Lucy and whether any precedent exists which may have to be followed in her case. You therefore have to consult the Constitution as well as PAJA, Correctional Services Act, regulations issued in terms of the Act, policy guidelines, case law. Only when all these sources have been examined and applied to the set of facts can you say that you have consulted all the sources to argue Lucy's case against the Department of Correctional Services. Activity 4.6. Read the AdLife Africa decision included in this guideline, Annexure B. Make list of sources used in the decision. Indicate which ones were more important and explain your answer. This is a self-evaluation activity. Apply the discussion of activity 4.5 guide you through your answer. Conclusion. In this learning unit, we discussed the sources of administrative law. We explained what is meant when referred to the sources of the law in general. We explained the sources of administrative law, and we discussed where to find the sources. Having examined in this first part of the study guide headed State Authority and the holders of such authority, question pertaining to what administrative law is, the characteristics of the administrative law relationship, the legal subjects of the administrative law relationship, and the sources of the administrative law. We next need to examine what administrative action is. As part of this study guide, Learning Unit 5, we examine the concept of administrative action and its importance. We have finished now our Learning Unit 4, and we say Da Nko.